liberal jurisprudence. Of course, that was not primarily the board, which was the Federal Court of Appeal in the beginning, and even the Supreme Court of Canada. So such concepts as a particular social group, identifying women as a particular social group, identifying family members as a particular social group. The issue of generalized violence, where many countries were saying that since they were not individually targeted, they were not viable claimants, or non-state persecutors, because it was not the state doing the persecuting. On all those, Canada was very, very early to say, look, the real essence is whether or not this person has a well-founded fear of persecution. Are they really going to suffer harm if they come back? So in those ways, it was a very progressive jurisprudence. And lastly, permanent residence. Many, many countries, the great majority of countries, just because they determined a person to be a refugee, they did not grant them permanent residence. The only obligation under the convention is not to refool them to the country of original persecution. So that's Dr. Jekyll. Now we get Mr. Hyde. One of the problems is in terms of although they developed this wonderful refugee board, to some degree they populated it with decision makers who were friends of the government, and both liberal and conservative governments went about that business. And with incompetent members, and there were unfortunately, particularly in the beginning, a significant number, they did not understand the law, they did not understand the complexities of the evidence, they did not understand legal procedures, so they could not preside at a hearing, and they did not understand the concept of bias. They produced a significant number of horrible decisions, and of course that brought the entire board into disrepute in several ways, and it also really undermined the morale of the very good members who are working quite the progressive ones I was referring to before. Some of the other bad parts of the system, although there was a right to counsel, a great number of counsel, because it did not have to be lawyers. Lawyers or consultants were either incompetent or unethical, and I include both consultants and lawyers in that comment. Along with that was lack of regulation from the law societies in terms of the lawyers, and this poor legal practice was a principal contributor to some of the poor decisions. There was no appeal in the beginning when the system was first designed. Actually, there was an appeal, and it was to the Federal Court of Appeal, and that's where some of the very good jurisprudence was originally designed, but then it shifted to a limited form of judicial review. I think it was in 1993 that happened. And with the new model of judicial review, the critical aspect of that is there's a triage process where only 10 to 14% of applicants even received a judicial review, and there were no reasons for those who were denied. And as well, because it was judicial review, the jurisprudence, that nice bedrock of jurisprudence framed by the Federal Court of Appeal, to some degree fractured, and you could really find a decision that would support any point of view that you had. And finally, in terms of permanent resident applications, although we did grant permanent residence, it was a very slow process in the beginning, a two-stage process. Persons accepted as a refugee, then they applied for permanent residence. That could take a year and a half, or 2 years, and only after becoming a permanent resident could they then turn around and seek to sponsor their family. And of course, we're talking about families that were very often in refugee camps or in horrific situations where there was a breakdown of the state or civil wars. Okay, I want to shift from there to Canada's current situation. And when I say current, I'm really talking about what happened post-September 2001 and 2002, and IRPA was brought in the spring of, Immigration, Refugee, and Protection Act. So here are some comments about the present system that's changed. First of all, more restricted access to the asylum system. There's still 98% access, but we saw the Safe Third Country provision come in. We saw a toughening of the attitudes in the Canadian Border Services Agency, a broader use of criminal eligibility provisions, and more aggressive detention policies. We went, of course, to single-member decisions, which you're all aware of, and linked to that, a failure to correct or significantly correct the GI, the Governor and Council appointment process. So although there was more merit considered in the selection process, it's still a GIC process that's slow, that to some degree, particularly in terms of reappointment, really still takes into account political factors. We don't know how much because it's a GIC process, so it's all within cabinet security. Professor Sean Rahog, and I hope Sean is going to make it here at the conference today or tomorrow, wrote a very good paper last year talking about the variance in the acceptance rate of members, and the variance was from 2% to 5% in terms of their acceptance of refugee claims. Well, there are factors that would explain some of those variances, but no factors would explain variances that broad. No refugee appeal division, it was in the law, but of course I think everybody in this room knows it wasn't implemented. There have been a couple of bills brought forward to try and order the government to do what's already in the law. What you may not know is that in the last 2 weeks, it's Bill C-291 in its current state. It passed second reading in the House. It went to the Commons Standing Committee for Citizenship and Immigration. And unlike the last time it made it through that process 2 years ago, this time the Liberal government surreptitiously and quietly supported the Conservative efforts to, they didn't defeat it, but what they've done is managed to bury it in the subcommittee, and my expectation is we're never going to see it come out, or if we do, it will be sometime in the late fall. So we're getting these nasty signals that the Liberals are really supportive of doing something other than the Refugee Appeal Division. And what that is, I'll talk about in a minute. In regard to the federal court, one of the small pieces of good news is that after 2000, the quality of the federal court justices at the first level, it's no longer the trial division, it's now the federal court. Quality of those appointments improved significantly, but as I've said, in terms of the leave process, it's only 10 to 14%. And there is a new report that is not yet out. It's a study done by Professor John Gould of George Mason University. It was a statistical analysis of the leave process in regard to IRPA applications and judicial review. Some of the significant findings, though, as to the variance between judges was between 26 and 98%, which was still very, very significant. And there's less excuse for those variances in doing a statistical analysis of many, many, many potential extra legal factors. The outstanding one is representation. You've got a 2% chance of getting leave if you don't have a lawyer. 98% are those represented, with a significant difference between experienced counsel. And when we say experienced counsel, because that's how it's measured statistically, we're really talking about the good lawyers as opposed to the horrible lawyers. Again, huge variance. So if you manage to get a good lawyer, you've got a very good chance of at least getting the judicial review. Well, that becomes an access to justice issue rather than the merits of the case. And once again, the problem being that we don't get reasons for leave that is denied. In regard to the Federal Court of Appeal, let me say this, many advocates are discouraged by the quality and the narrowness of the decisions of the Federal Court of Appeal. There are many areas where the Federal Court has issued quite innovative and quite courageous decisions, particularly in the areas of safe third country, state protection issues, particularly Mexico, conscientious objection, the use of the exclusion clauses, particularly 1FD, which is serious and unbelievable crime, and the security cases such as Chicago. In all instances, the Federal Court of Appeal has taken a far narrower view, far restrictive view, and if I can say this and make it sound immodest, I'm going to have to, but quite frankly, the quality of the reasoning and logic is, at best, disputable, at worst, offensive.